Welcome. I'm Ron Cass. I'm Dean Emeritus of Boston University, which means I'm too old to be a speaker, but they let me be a moderator. And for those of you who want the full bio, there's a 3-volume backup set that's available outside. This panel's title is Government Friend or Foe of Innovation? And when I looked at the title, I thought immediately, yes. That was the answer. It reminded me of a conversation I heard between two friends at a cocktail party. One was a lawyer and one was a doctor. And the doctor said to the lawyer, how do you set your charges? And the lawyer said, I charge $10,000 for 3 questions. To which the doctor said, don't you think that's a little steep? The lawyer's answer was, no, what's your 3rd question? The panel title masks the fact that innovation plays just an enormous role in all of our lives. Anybody who was in the military and ever ate C rations or K rations or any cold food appreciates the invention of fire. Anyone who's ever carried anything a long way appreciates the invention of the wheel. If you look at the last century, in the 20th century, the life expectancy went from the mid-40s to the mid-70s. Now, the mid-40s was very important because when Social Security started, the age of expected death was before you could start receiving Social Security. Government programs haven't adjusted to some of the changes over that century, but a lot of the change in life expectancy was driven by changes in health that were the result of innovations, the invention of new drugs and procedures. We also had a huge change in the way people go about transporting themselves from place to place. At the beginning of the 20th century, a lot of transportation was still by horse. By the end of the century, you had people taking supersonic jets and traveling on rockets. You had a real sea change in how quickly goods could get from one place to another and how cheaply they could get there, which changed a lot of the rest of how we live our lives. Communications. We now have ubiquitous, these little cell phones, which I'm supposed to ask you to turn off. At the beginning of the century, people would communicate by mail. People used to be able to write letters instead of tapping things out or tweeting or texting. There has been a series of innovations that drive the way we live, that make it cheaper and easier and faster to communicate and to ship things and to get a variety of goods from around the world to places where we want them to be. The innovation that we see in this country also drives the economy. About 1/3 of the economy is in IP-intensive industries, but that accounts for about 50% of our GDP. It accounts for more than 60% of our exports. We are in international markets, and our problems and solutions on innovation are also in international markets, and we see evidence all the time of the challenges as well as the opportunities that gives us. When we look at government's interaction with innovation, government actually funds a certain amount of investment, and there are questions raised about the selection of what it is that government chooses to invest in. Government also sets the ground rules for intellectual property. It defines the intellectual property rights. And we have a series of questions today about the definition of those rights and whether we are defining them the right way, whether we ought to make changes in that. The notion of IP rights itself is under attack in the academic community. A lot of academics who copyright their own work think that copyrights are a terrible thing. A lot of academics who benefit from patented innovation think that patent law needs radical revision. And in addition, the government intersects with innovation in regulating the use of things. It tells us what we can and can't do with innovations. It regulates exports. It constrains the way we deal with our computers. It really has almost every edge of innovation touched in some way. Our panel members today are going to talk about how government affects innovation, what it does good and bad, and what should be done about that. I will quickly introduce them. They will come up and speak. Their full bios are available outside. Our first speaker will be Gigi Sohn, who is the president and co-founder of Public Knowledge, a nonprofit organization. She's also a senior adjunct fellow at the Silicon Flatirons Center for Law, Technology, and Entrepreneurship at the University of Colorado, and is co-chairman of the board of directors of Broadband Internet Technical Advisory Group. Our second speaker will be Neil Freed. Neil is the Majority Chief Counsel for Communications and Technology of the House Energy and Commerce Committee. He is a refugee from the Federal Communications Commission and from private practice. Our third speaker will be Damien Geradin, and he is the William Cook Global Professor of Law at the University of Michigan, as well as a professor at Tilburg University in the Netherlands, and a partner at Covington and Burling in Brussels. Each of those organizations has disclaimed any knowledge of what it is he's going to say here today. Our final speaker is Josh Wright. Josh is a longtime commissioner of the Federal Trade Commission ever since January of this year. Prior to that, Josh was a law professor at George Mason University School of Law and had previously been in the FTC serving as a scholar in residence at the Bureau of Competition. Let me turn the program over first to Gigi, and we'll come back with audience questions after our speakers.
Do you want me to come up there?
You can do wherever you like.
Well, I can't see the people over there, so I will stand up. And as is the case with every one of my speaking engagements, I must bring the microphone down.
I never have people do that.
So good morning. I want to thank the Federalist Society for inviting me here. This is the third leg of my one-week Glutton for Punishment tour. Last week I spoke at the Free State Foundation conference on what would you do if you were FCC chair, and that's a libertarian think tank. Then I spoke at the World Creators Summit the same day with a bunch of folks that believe that copyright is not strong enough and should be much stronger, and I got hissed for merely saying what my organization does. So this is the third and final leg and most enjoyable. I think this is about the fourth or fifth time I've spoken in front of the Federalist Society, and I really enjoy it because everybody gives me a good hearing, and at least one person comes up to me afterwards and says, you know, I don't agree with you, but you made me think. So that's, to me, that's progress. So for those of you who don't know about public knowledge, our goal is an open and decentralized communication system that lacks gatekeepers. And we do believe that occasionally government action is necessary to promote that goal. We work mostly in the telecommunications and intellectual property fields. I'm proud to say that we just hired our first patent attorney. I know nothing about patents, so they can just talk about it all day. So, but I am going to talk about copyrights. So I agree with Dean Cass that whether government is friend or foe, it's not a binary choice. In the fields that I work in, telecommunications, internet, copyright, the government has been both a facilitator of and a hindrance to innovation. And what I want to do is I just want to quickly tick off three areas where, or three instances where I believe the government has been a facilitator of innovation. And because I know my audience, I'm going to tick off four instances where government has been a hindrance. So first and foremost, the FCC, starting in 1966, came up with a series of decisions that really, one could argue, and I would argue, led to the commercial internet that we have today. The first decision, known as the Carter phone decision, this was 1966, said that AT&T couldn't prevent you from putting non-harmful devices, or as it's known in the trade, customer premises equipment on their network. As long as it wasn't harmful, you couldn't be prevented. You didn't have to go to the AT&T store and rent a phone. Does anybody remember that, when you had to go to the AT&T store and rent a phone from them for $10 a month? So this led to everything from answering machines to fax machines to eventually the computer modem. So that certainly was a pro-innovative decision by the FCC. The computer inquiries started in 1966 and stretched all the way to 1986. There were three of them. And it's hard to explain what these are simply, but let me try. The purpose of the computer inquiries was to make sure that the telecommunications system was an open platform. And in doing so, the FCC defined basic transmission services, so kind of like, the telephone system, and so-called enhanced data services. So to protect against the potential anti-competitive behavior by the telephone companies, the FCC created a series of separation rules that sought to protect against such things as improper cross-subsidization, improper discrimination in favor of affiliated services, and other anti-competitive behavior. So this was 1986 when the third computer inquiry was finished. So in 1989, you had your first commercial ISPs. In 1991, you had the first exchange point for traffic between commercial internet backbones. In 1991, the World Wide Web was developed. The White House went online in 1993. In 1994, Congress went online. I think it is not, would be not a wild thing to say that by distinguishing between basic and enhanced services and making sure that the telephone companies, the regional bell operating companies, could not discriminate against enhanced data services really opened up the internet to where it is today. So the second pro-innovation decision was GPS. GPS, Global Positioning Systems, people may or may not know, was actually government-made and government-run. And it was just given to business for free. And I don't think I need to explain how terrific GPS is. I travel a lot in Los Angeles. It saved my life many, many times. And third, and this is something where my friend and colleague Neil may disagree with me, is the increasing allocation of spectrum for unlicensed uses. So what has this led to? Wi-Fi, garage door openers, retail store inventory systems like the RFID chip, medical equipment, wireless headsets, keyboards, and phones. In just one band, the 2.4 gigahertz band, there are over 20,000 different unlicensed devices certified there. So it's just, you know, I'm not one of those people who thinks everything should be unlicensed. I think there are good licensed uses for spectrum, but I do think there needs to be a significant amount of spectrum set aside for unlicensed uses, and the proof is in the pudding. I mean, Wi-Fi is used by everybody, including the wireless carriers, to offload traffic when they have a lot of congestion. So let me talk about the bad stuff, my 4 examples. First, the FCC decided, you know, I don't remember, I think it was the 1970s, 1980s, not to allocate spectrum for AM stereo. So we had FM stereo. They decided, let the marketplace decide. Of course, when you're talking about the government licensing spectrum, and there isn't really a free market to begin with, and that set back AM radio for many, many years. AM now is stereo, but I think it took about 30, 40 years for that to happen. Second are just generally regulations that protect broadcasters from competition. I was very involved in the first allocation of satellite radio slots. And I remember the broadcast industry coming to me and saying, let's put all these, you know, public interest obligations on them, and let's make sure they can't do local programming. And in the early aughts, XM Sirius wanted to do local programming, and the broadcasters went to the FCC and says, no, they can't do that. We have a monopoly on localism. They don't do it very well, but they do have a monopoly on it. Third is one of my favorite FCC non-innovative regulations, one that my organization defeated in court, the so-called broadcast flag. So the broadcast flag was a requirement that every device, every digital television device, and every device downstream from a digital television, so you know, your digital video recorder or your computer, would have to read and obey digital rights management embedded in a digital television signal. That would have prevented you from, if you appeared, let's say, on a television show, would have prevented you from sending that over the internet to your mother, among other things. You know, profoundly anti-innovative. What happened was, even though we challenged the FCC right away, these rules right away, the FCC went ahead with a process where they certified devices that were broadcast flag friendly. So imagine that, you know, every couple years the FCC having to approve a new device for use with this broadcast flag. Luckily, not luckily, as a result of many hundreds of thousands of dollars spent, the DC Circuit said that the FCC did not have the jurisdiction under the Communications Act to basically tell devices what to do. And at oral argument, the liberal judge, Harry Edwards, said to the FCC solicitor, if we went the way you went, if we said that the FCC's jurisdiction is what you say it is, you could regulate washing machines. So that was obviously a big victory and just a terrible rule. Finally, very quickly, copyright law and enforcement post-1998. The Digital Millennium Copyright Act, the increasing enforcement of copyright for, really halting legitimate uses, statutory damages, $150,000 per infringement if you are, if you're taken to court and found to be infringing. I mean, imagine what venture capitalist is going to give money to a company that has a legitimate device that could infringe. So the length, the strength of copyright right now is profoundly anti-innovative. So what ties these things together, and then I'll stop. So my belief is government does better when it opens up closed platforms and concentrated markets to competition than when it seeks to protect particular distribution models. And that's really the four things that I named are really where the government was trying to protect a particular industry, whether it be the content industries or the broadcast industries. That's when they really, really fail, when they're protecting incumbents. When they're opening up platforms to competition and new entrants, that's when the government promotes innovation. Thank you.
Hi, I'm Neil Freed. As mentioned, I'm the Chief Counsel for the House Energy and Commerce Committee, responsible for communications and technology issues. So over about the past decade, my exposure to the intersection of government innovation and innovation has been in the communications sector. And while I think much of what Gigi has said is accurate, it's probably more accurate for sort of a generation, a time that's passed. When we had Ma Bell, we had one monopolist provider in communications. Intervention, I think, arguably was more necessary. But the modern communications marketplace is very different. It's very dynamic, and it is not anymore the poster child for the type of industry where government intervention will be successful. We have rapidly evolving technology. We have growing intermodal competition. We have cable competing with phones, competing with wireless, competing with satellite, competing with the internet. We have an influx, a massive influx of capital from the private sector. They are spending their own money to build out innovative products on a daily basis to the tunes of tens of billions of dollars. And it is a quickly changing business model. Everyone is scrambling to figure out how they can get eyeballs because everyone has far more choices than they have ever had. And it has become ruthless. Companies are constantly out innovating each other, coming up with new business models, and that's why we have this chaotic innovation. So I look at it slightly different. Unfortunately, over the last decade, I don't think the FCC, if you look at their regulatory track record, has a lot of innovation that they can claim as being responsible for. I'll look through some, and I'm trying not to take too much time, but I look at the internet slightly differently. I look at the success of the internet, actually, as starting when the government got out of the business. It was when it was commercialized. It started out as a DoD project, a research project, so that government agencies could communicate with each other. It was only when, through passage of law, through Congress, so Congress did do something good here, but what Congress did was it got out of the way. It said, okay, we're going to allow the commercial sector to get in. And that's when the commercial sector got in a largely unregulated manner, that we saw the internet take off. In 1996, we had the Communications Act, and one of the pivotal provisions of the 96 Act referred to something called unbundling. And what unbundling was it said that incumbent providers had to make piece parts of their networks available to their competitors at a cost-based rate, essentially allowing their competitor to use their own facilities to compete with them. Horrible for investment, took millions and millions of dollars both in implementation and in litigation. It went round and round. Eventually, the FCC had to dismantle it. And this is important to recognize. Even if it had succeeded, it would not have led to innovation because it was price competition focused. It was trying to get prices for something lower. That's not innovation. Innovation comes from product competition, from service competition. But in this model, no one was providing anything different. They were using their competitors' own facilities, their own services, to provide the very same facilities and services. So I'm not sure that was a terribly, well, I know that it was not a terribly successful endeavor since it really hasn't, it's been dismantled. We can look at mergers. I would argue that under a merger analysis, what the agency should really be doing is looking for, if there is any merger-specific harm because of a market failure, and tailoring whatever remedy it needs to that merger-specific harm. But that's not what the FCC does. The FCC often tries to anticipate, to guess what the future innovation might possibly be, and to create prophylactic rules to sort of pave the way for this guess as to what the future will pave. And I guess the best example is AOL Time Warner. The FCC fixated on advanced instant messaging, was sure that that was the future. And it created all these conditions, and two things happened. First, advanced instant messaging really wasn't the be-all and end-all. And second, neither was AOL Time Warner. So, I mean, a lot of effort spent in guessing where the market should go and anticipating really does not foster anticipation. We have the broadband stimulus in 2009. $7 billion allocated to the subsidy of the build-out of broadband. What people forget was at the time, before this even was put into law, we already had 96% of the country with access to broadband. 2/3 had subscribed, and we had gone from 8 million to 200 million subscribers in the last decade. So I really am not sure why there was a need to do this in the first place. Second insult to injury was that the money that was spent was not focused on that 4% of the country that didn't have access. Instead, it was available to just about anyone who could make the case that they were going to do something useful. And what you ended up having was overbuilding. Competition, government-subsidized competition with existing providers, which actually hurts both sides because the government dollars are competing with the private sector dollars, and both of them have a harder time. If you look at the flip side, the private sector, and this is the investment I was talking about earlier, is investing on average $65 billion per year in investing in broadband. And I don't know why we would think that a one-time $7 billion investment that's duplicating the existing investment that the private sector is doing is going to lead to innovation. The next I'll talk about is there's a bit of a bright spot, and I would say that auctions and spectrum, the FCC has done some terrific things. We have learned, thanks to a Nobel laureate, that auctions are actually a far better way of allocating a scarce government resource than what the FCC used to do. The FCC used to have what were affectionately called beauty contests. If you could convince as few as 3 commissioners that you were the right entity with the experience and had the right business model, 3 commissioners would just give you the spectrum. It was a pure beauty contest, and the argument was, he or she who lobbied best essentially won. That didn't go so well. We learned from that lesson. Unfortunately, we went from that to random assignments, literally ping pong balls determining who would get spectrum. Also not a terrific way to promote innovation. Where we got to now is auctions, and that's been very helpful. By moving to an auction process where businesses compete in a real time, right? Whatever the current demand is, whatever the current amount of spectrum available, the current bands that are needed, they all compete and say, I've got the best business case. And if they can demonstrate that they're going to raise enough money to actually sell their services to meet a consumer demand, they will likely have enough funding at a given time by meeting the best social need at the moment to win that spectrum. As a result, we've raised tens of billions of dollars for the federal government, but more importantly, unleashed huge innovation in the wireless space. All these phones that we've been talking about really come out of this move towards auctioning spectrum, making sure that people compete in the marketplace to meet current demand based on current technologies. Where the FCC is starting to go wrong, however, is they're drifting from this objective auction-based mechanism. Instead, they're talking about conditions, they're talking about excluding parties from auctions, they're talking about going back to the beauty contests and saying, you know what, we, as few as 3 commissioners, think we know the best use for the spectrum, and it's not going to be for an auction. For licensed use, it's going to be for unlicensed use, or it's going to be for smart meters, or it's going to be for something else. I fear that we are going to snatch defeat from the jaws of victory. The things to remember, I think, are that there are laws of economics and laws of physics, just like there are laws of gravity. And when the government tries to influence the laws of economics and laws of physics, it will likely be just as successful when it tries to influence the laws of gravity.
Well, I would like to thank the Federalist Society for inviting me to take part in this panel. So I don't think we can say that the government is a friend or foe of innovation. It really depends. But what the government can do is to adopt measures that will have positive or negative impact on innovation. And that's what I would like to talk about. I'd like to say a few words about standard essential patterns. So standardization is very important. The reason why we can all communicate with smartphones is because these devices are compliant with some standards, initially 1G, then 2G, more recently 3G. And I think that 4G devices are already being sold in some parts of the world, probably the US. For a long time, standardization was only about making technological choices. Engineers from large companies were meeting in different places to discuss what would be the best technologies to solve technological challenges. That worked pretty well. Of course, in recent years, intellectual property rights have taken more importance. And standard-setting organizations, there are many of them, but the big ones basically adopted IPR policies. And according to these IPR policies, when companies participate in standard-setting organizations and realize that in the committees, technologies on which they have intellectual property rights are being discussed, they have to do two things. They basically have to raise their hand and say, hey, I may have a patent or several patents on that piece of technology, so you have to disclose. And then subsequently, you're asked to make a so-called friend commitment. In other words, you're asked to commit to license your patents at fair, reasonable, and non-discriminatory rights. Now, of course, people may disagree about what friend means. Of course, what is fair and reasonable to me as a licensor may not be fair and reasonable to you as a licensee. And that triggered significant litigation. That also triggered antitrust complaints in various parts of the world. So I started being involved in that standards business in 2005, where a number of companies filed antitrust complaints in Europe, but also in other parts of the world against my client at the time, a company called Qualcomm. And the claim that was made in these complaints was that the royalties that had been agreed in licensing agreements between Qualcomm and these manufacturers were too high. And I think the reason why the complaints were filed in the European Union is simply because at the time, I don't think the US authorities, the US antitrust authorities would have been interested in taking such cases. So Europe was the natural venue. So we spent a lot of time fighting these allegations, and eventually in 2009, the complaints were entirely dismissed, and Qualcomm also settled private lawsuits with most of the complainants. So at the time, we thought that that was it. These were bad complaints, and the matter was settled. But that did not happen because just a few months later, another wave of lawsuits and complaints were initiated, and they related once again to standard essential patterns for mobile devices. And this time, interestingly enough, the US antitrust authorities took a lot of interest in these complaints. And I think the first major outcome was a report which is called the Evolving IP Marketplace. This report was issued in 2011. And that report is an interesting piece of work, but what I found quite striking about it is that it was terribly one-sided. Let's be clear, I'm not, by definition on the side of licensors or on the side of licensees. What matters to me is that there's a certain balance in policy discussions and in decisions taken by authorities when it comes to standard essential patterns. For instance, that's a report where you have a lot of quotes. Scholarly papers are quoted throughout this report, but I would say that 99% of the quotes are going in one direction, essentially people who want to weaken patentees' right, and I found this a little bit shocking. Now, 2013 has been quite interesting for a couple of reasons. First, the Google consent decree was adopted, and the Google consent decree constrains Google's ability to seek injunctive relief for enforcing its standard essential patents. Essentially, Google must make an offer to potential licensees. That's a complete offer. And then if there's a disagreement with the potential licensee, it has to wait 6 months, and then it can seek an injunction. But before doing that, it has to offer binding arbitration. And the arbitrators will be asked to determine what the FRAND royalty rate is. Or they could also look at different licensing terms, but essentially it's going to be about the royalty rate. At the same time, you have a decision that was adopted just a few weeks ago by Judge Robart, is a district court judge in Seattle, which offers a methodology to whereby you could set FRAND rates. It's again an interesting decision and a good contribution to the debate. Now, against that background, I essentially have two concerns. I think the first one is that although it could be argued that some licensors, some people who have big patent portfolio that are essential to these sort of devices, were a little bit too greedy, a little bit too aggressive in their licensing approach. But I think we should avoid the pendulum swinging too much in the opposite direction, because the reason why all of us have these wonderful smartphones with lots of different functionalities is because companies spend a lot of money and millions of man-hours to develop these technologies. And of course, if you constrain their ability to generate revenues from their patent portfolio, it is clear that there will be less investment. And I think that the discussion over unbundling of the local loop is quite revealing. In the European Union, it's been a complete catastrophe, because the net result of this is that because it was so easy for competitors to have access to the incumbent's network, the competitors decided to invest less, and the incumbent decided to invest less as well. And now, of course, 20 seconds. Now, of course, the European Commission is very concerned about encouraging investment. My second concern is that there's a risk, of course, that if litigation is the better way to proceed for potential licensees, we will replace commercial negotiation, which is the way things have been done so far, by litigation and rate setting by judges. And I don't think this is what we want, because we want less litigation rather than more litigation, and I think private parties are better able to set licensing terms than judges. So to cut a long story short, I think it's really critical that the FTC and the US authorities in general avoid moving from one extreme to the other extreme. I think we need to find a fair balance between the interest of innovators and the interest of implementers. Thank you very much.
Hi, I'm going to focus my remarks on, perhaps not surprisingly, the role of the FTC in particular its competition enforcement and the implications for innovation policy. I should start by saying that the one thing I've got a hang of in my 5 months at the Commission is starting all the speeches by saying, what is it? My remarks aren't the views of anyone else, more or less, but especially the other 3 commissioners or commission staff. Okay, so the FTC's role in enforcing the antitrust laws is to provide a backstop to prevent practices that harm competition. We normally think of these in the sort of brick and mortar world, gas stations, 2 gas station owners meeting in the middle of the street to fix prices. Okay? But just as there are business practices and conduct that can harm competition and have price and output effects, right? Any Econ 101 textbook tells you that sort of conduct, a cartel, increases price and reduces market output. There are businesses practices out in the world that can harm innovation. Now, the role of the FTC when it comes to business practices that impact innovation rather than price and output, or impact innovation in addition to price and output, is in some ways no different. The FTC's role in enforcing the competition laws in a free market economy is a significant one, but that role is as a referee and not as the star player, to borrow a phrase from my former George Mason colleague and chairman of the FTC, Tim Muirs. In its role as a referee and not a star player in governing competitive practices that impact innovation, the FTC has a couple of key tasks. The first, of course, is to be able to identify and then investigate and prosecute practices that clearly harm innovation, and to stay its hand when they do not. Now, there are a couple of other things the FTC does. It has a unique policy authority, and I'll talk about that in a little bit. But let's start with what really is the bread and butter of enforcement efforts, that is identifying those practices that harm innovation and distinguishing them from those that are either competitively benign or those that actually help innovation. None of this is to say that antitrust analysis in high-tech markets or markets where innovation is an important part of the competitive dynamic is no different at all than in the brick-and-mortar space or in spaces with low innovation. I realize there's lots of innovation in brick-and-mortar. It is a little bit different. It's a little bit different for a couple of economic reasons and at least 1 or 2 practical reasons as well. One is that Dean Cass started off talking about how much it is that economic growth is driven by innovation. This is, as many of you know, I'm often on, well, you may not know, but you've often seen panels with battling economists, and 2 economists, joke about how many more than 2 opinions you'll get. Most will agree, any that have read the literature, that one stylized fact that all economists agree upon is that innovation really is the thing that we know drives economic growth, quality of life, living standards, etc. Well, that makes enforcement decisions in this area higher stakes than normal, higher stakes than when we're talking about practices that involve what we normally think about of static product competition in the market. Economists will call this, often describe this form of competition as dynamic competition. Errors in either direction, either wrongly condemning an anti-competitive act or incorrectly staying one's hand in a practice that harms innovation, have much more dramatic consequences in this setting. Frequently at issue in these cases, another difference, are new business models. By definition, we're talking about innovation. New business models, experimentation, new practices that the commission or the agency or court hasn't seen before. This is where I think I'll take a slightly different stand on the friend or foe question. I think in the case of antitrust, it's pretty darn clear from the historical record from 1890 to 1977 at least, and probably into the 80s, when the FTC released what are now quasi-affectionately known as the 9 no-nos, the guidelines for licensing intellectual property, which essentially said, no, don't, that the antitrust laws had taken a fairly hostile stance to new business practices and innovation. That history should inform how we think about competition efforts moving forward. That entire hostile era was also well before the integration of modern economics into antitrust law. And that's an important difference. So we'll talk some about what modern economics can teach us about how to go after the bad stuff and stay our hand when it comes to practices that are either competitively benign or helpful to innovation. So in order to avoid this sort of tendency in antitrust over time to go after, to condemn false business practices, I think it's fairly important to take a evidence-based, data-first approach to identifying that sort of conduct. There exist easy cases in this space. There are still cartel cases. There are cases in which two competing firms who compete against each other by innovation rather than price competition agree, hey, let's stop competing. That is illegal. It should be illegal. That is not a help to innovation. When the FTC or an enforcement agency goes after that conduct successfully, it is a friend of innovation, not a foe. In this space, there are very few easy cases, and I think that's one of the important lessons for competition enforcement surrounding innovation. The simple fact is that the bread and butter of antitrust enforcement in either merger or monopolization cases require predictions about how a particular practice will influence innovation in the future. In the brick and mortar gas station case, any Economics 101 textbook gives you a pretty good idea, at least an analytical framework to hang your hat on to make those predictions. In terms of predicting innovation, no matter what any competing economists tell you, even me, it will always be the case that predicting the future is much harder than predicting the present. What does economics say about predicting how particular business practices are going to harm innovation? Not much yet. Well into the debate in this literature in antitrust, there exists no real agreement on the relationship systematically between competition and innovation. This is the great, for the economist readers in the room, Schumpeter versus Arrow debate, whether more concentrated or less concentrated market structures give us more innovation. So what we're left with is a very fact-intensive, a very data-intensive approach to antitrust analysis as being the safeguard against ensuring that the FTC or other enforcement agencies don't overreach in these areas. There's one area in which, well, I'll save for questions, but there's one area in which I think outside the realm of enforcement where it's important to note, and then I will sit down. The FTC has another important role to play here, which is in its competition policy advocacy efforts. I noticed as I was walking out of the room, walking into the room, Senator Cruz was leaving. He used to run the Office of Policy Planning shop at the Federal Trade Commission, which is responsible for our advocacy efforts aimed at state and local regulation. One of those efforts that comes to mind that's relevant to the innovation debate is the Commission's recent advocacy efforts to state and local regulators, City of D.C., State of Colorado, regarding state or local regulation meant to thwart smartphone apps some of you may have on your phone right now involving things like Uber to get taxi cab services. This is a role the FTC has historically been on the right side of innovation, continues to be on the right side of innovation, and again is an example of picking cases where we know, or picking policy issues where we know the data is clear. We've identified conduct that harms innovation. In this case, the conduct is state or local regulation, and either through policy authority, FTC is a very unique policy authority in this regard, or through enforcement efforts, protecting consumers by using its full toolkit. Thank you.
Well, I'd like to thank the panel members. Neil Fried had to leave for another engagement partway through and asked that I make his apologies. Before we go to audience questions, let me ask the panel members if anyone has something to pick on one of the prior speakers.
Well, I feel like it's kind of unfair because Neil isn't here anymore, but I do think he overstates.
You're at the Federalist Society. We don't believe in fairness.
I do think he overstated the amount of so-called intermodal competition. So as he said, the cable and telephone companies are competing against each other. But with the FCC and the DOJ's approval of the sale of pretty much, I think, all of the cable industry's spectrum to Verizon last year, there really isn't any intermodal competition anymore. You basically have AT&T and Verizon, which are by far the most powerful wireless companies, controlling about 70% of the wireless market, and then in each region you have a regional monopoly, and if you're lucky, a duopoly of 2 wireline competitors. So that would be the only thing I say is he everybody talks about, well, it's not AT&T where there was a monopoly, but in a lot of areas you actually have regional monopolies. Most Americans don't have a choice of more than 1 or 2 internet service providers, wireline internet service providers, and you have a duopoly. I don't think that makes things a whole lot better and means that government should not try to open up competition like they did in the instances that I talked about in my talk.
Damien?
Yeah, I just wanted to say a few things about the time horizon, which I think is incredibly important. I mean, of course, if you look at things today or tomorrow, you might think, well, it would be much better to have more competitors. It would be great to subsidize entry. It would be fantastic to have access to all these wonderful technologies at low cost, right? Which is true, actually. Immediate competition will deliver results in terms of lower prices. Access to technologies will permit manufacturers to come up faster with new devices and so on and so forth. But at the same time, we should not forget that for people to invest in innovation, they need the right incentives. So that means that by focusing too much on competition and price competition in the short run, you may actually discourage people to invest in very expensive, time-consuming research and development programs. And at the end of the day, it also depends what you're talking about when you talk about innovation. I mean, are you talking about a new device which has, a slightly different keyboard and maybe a slightly bigger screen or something of that type? And of course, this is what drives consumers to buy an iPhone versus a BlackBerry, these sort of things. Or are you talking about the sort of fundamental core innovation that just allowed these devices to be created and manufactured in the first place? So I think, the time horizon is incredibly important when you talk about competition and innovation.
I'm good.
I had heard that, but not from reliable authority. Let me ask, people have questions to go to the microphones on either end of the room. And I will remind you, we have 3 law professors up here, so if you don't have questions for us, we'll have questions for you. I was struck by the fact that all of the speakers focus so much on regulation rather than direct investment by the government. And I was struck, Gigi, when you said that the FCC should get credit for inventing the internet. I thought it was Al Gore all this time.
Well, I did talk about GPS, though.
Yes, you did.
Yeah.
I also was struck by the fact that during the program, I got a call from the Chinese government asking if the speakers could speak a little louder so they could hear better.
Chinese government or our own government?
Let me start with the microphone over here. And if you could identify yourself and say to whom the question is.
I'm Russell Page. I'm a patent attorney, and my question is primarily for Gigi Sohn.
Because she said she didn't know anything about patents. Got it.
I know enough to fake it. Yeah.
Milton Friedman spoke very effectively about eliminating the FDA and letting the market take over the role. Do you see an analogy with the FCC?
Would say that and letting the market, I think that would be a complete disaster. Look, I agree with my friend Neil Fried that the FCC is a very imperfect agency. It's subject to capture by industry. It's slow to move. It has a lot of problems. I don't think the answer is getting rid of it. I think the answer is getting somebody in the chair position, and I believe the next chair is going to be that, who is mission-driven, who understands the role of the agency and puts good personnel in there. I think if you left the FCC's function to the marketplace, you've almost recreated the AT&T monopoly. That's exactly what would happen. And at best, you'd have a duopoly. I don't see how the licensing of spectrum could be left to the marketplace. I don't really see how a lot of the consumer protections, the charges that telephone companies charge for third-party services, the outrageous charges, how that could be left to the marketplace. I just think that the FCC has a role to promote competition and consumer protection. The fact that they haven't done a particularly good job of it in the last decade is more to the leadership than to the mission.
When you talk about abolishing the FCC, students of history will recall that it started life as the Federal Radio Commission with a one-year charter. So here we are in 2013. This was starting out in, I think, 1927 was the beginning of the FRC. So it may be tougher to get rid of than we think.
If I may, I'd ask another question, and this one would be for Professor Wright. Can you tell us the FTC's two best achievements, particularly from the standpoint of consumers?
Other than hiring Professor Wright as a scholar in residence.
Sure. Do not call under Chairman Muirs, I think is widely considered to be a fairly dramatic success. And the writing along with the DOJ of the merger guidelines, which took incredibly backwards antitrust law in the Supreme Court governing mergers in the 60s and turned it into an economically rational, imperfect, but rational policy today, I think, are two easy ones.
You have a question to this microphone?
Well, Professor Cass, your question and all honesty, or your comment earlier prompted my question, and I invite other members of the panel to respond. My name is Terry Campo. I was a DOE lawyer in the Reagan years and had to sign off on a reprogramming of Defense Department funds for this crazy idea called an ARPANET, which I didn't understand at that time. But one of the things that I do now is, of course, with the DOE background, is involvement with grants for new technology developments. Particularly, of course, nowadays it's all alternative energies is what everybody was trying to chase the money for. But here's the thing. Every federal grant gives the government a royalty-free use of any patents developed under that grant. Particularly for those with that economics background, when the largest consumer of any product in the world is the government of the United States, are we in effect not crippling any technology's commercialization when we have that provision? Thank you.
Is that for me?
You want to take a first crack at that?
I'm not sure I understand the question. Give me the last part again.
Well, essentially what comes down to is with the royalty-free use of any patents developed under a federal grant by the private sector, by a private business or one of the national labs, we are effectively, because the U.S. government is the largest consumer of almost all commodities and technologies, we are taking the largest buyer out of the market that the company could capitalize from.
Yeah, so I think the reason I didn't understand the question is because I don't think it was one. I don't think I disagree. I mean, I think the implications of what you're saying are fairly obvious. If you take the largest buyer out, you shrink the size of the market. The effects on that, by the way, could go either way in terms of the market price that prevails. Depends on the marginal buyers who are left, right? When you take the marginal buyer out you certainly shrink the size of the market, have effects on the incentives to invest, which is, I think, where you're going with the questions. If you're asking me if shrinking the size of the market makes people less interested in entering the market, I think this is one of the gravity laws of economics things. I agree.
Yeah, but this
It
is
really
a
is.
situation when the government is giving you money to develop the technology in the first place.
Yeah, so the ultimate
I mean,
effects.
it's pretty settled that the government can ask for those kind of conditions.
Yeah,
when it
so I'm
gives you
not
money.
talking about the legal authority at all. I mean, he's asking what happens when you shrink the size of the market. There's an effect. Now, there could well be an effect from the direct subsidy. It could be a good one, and it could swamp any of the bad effects. I don't know the literature on this or have any ultimate empirical answer. I'm just saying that water runs downhill.
We have another question. I think we can all agree on that one. And particularly those of us who were awake during the storm last night.
Hi, thank you for wonderful presentations. My question is an attempt to kind of bring in some of the earlier discussions from the first panel to this panel. So the opening panel focused on how do we protect the rights of citizens in the environment of agency investigation. And so my question is, when you're investigating and figuring out how to protect innovation, and innovation is for the sake of consumers, you're still investigating real people and real companies. So how do we have a process that actually protects the people who are being investigated in a way that also, how do we have a concern both for the consumers and those who are being investigated? What are the processes that will protect the people who are being investigated in this process?
Anyone want a first crack at that?
I think that many, lawsuits and complaints, especially complaints to antitrust authorities in the United States and in Europe, are basically part of commercial warfare. One of the things you want to do is to attack your direct competitor because these investigations are terribly costly, they're terribly bruising, they take management time away, and they damage your reputation. So now I'm afraid that there's no real solution to these problems. I think the only way to avoid that would be to prevent complaints from being filed, which is probably not a good thing. I think what is critical probably to avoid, to protect companies is to not only have a fair process, but also to have a relatively speedy process. I think, especially in my jurisdiction, which is the European Union, these investigations can take years, sometimes up to 10 years. And that's really, really bad. I think you need to have a quick solution so that if there's a harm, then it should be redressed. If there's no harm, then the matter should be basically closed.
Ron, can I just say one thing? I just think that there's a conflict here between what's necessarily good for the companies and what's good for the public. I mean, the Google investigation of the FTC to me is a perfect example of you need to have some opaqueness to protect trade secrets and to protect, certain assets of the company. On the other hand, the public had no idea what was going on. I mean, you had this 2-year process, and all of a sudden, the FTC basically, with a paragraph, said, "Oh, nothing to see here. We'll fix some standard essential patent stuff, and we'll be on our way." So I think there's a very, very difficult balance, and I'm not necessarily sure you can align the interest with the companies being investigated with the interest of the general public in knowing what the heck its government is doing.
I think the underlying point is that we have engagement at the investment stage, we have engagement at the stage of encouraging and protecting innovation, and we have engagement as well in the question of how you use it. And the government is touching all of those. During the Reagan administration, one of the lines that became famous was that there are really 3 rules for regulators. The first is if something moves, you tax it. The second is if it keeps moving, you regulate it. And the third is when it stops moving, you subsidize it. And I think we can agree that those are still rules to live by. We are at the witching hour, the end of the panel. I would like to thank both the members of the panel and the audience for your attention. Look forward to seeing you.